Okay, let's unpack this. Imagine a scenario that sounds, well, like it's ripped straight from a legal thriller. A convicted killer, decades into his life sentence, comes up for parole.
Right.
But instead of a standard board review, he hits this legal brick wall, a really controversial law known starkly as no body, no parole.
And this wasn't just, a procedural hurdle. It ignited a constitutional firestorm. Really did. Went all the way to the highest court in Australia, the High Court.
Wow.
That's right. This case, Cherry v. Queensland, it's just this profound collision of, a horrific crime, a tough new law, and these fundamental questions about how power is divided in our legal system.
Pitting the individual against the state.
Absolutely. It forces us to look really closely at the lines between judicial punishment and executive mercy. It's a legal battle that one source we've looked at actually describes as one of the most ethically and constitutionally significant criminal cases of the decade.
High stakes doesn't even begin to cover it, then?
Not at all.
So in this deep dive, we're going to trace the entire dramatic arc of this case for you. We'll start with the crime itself, the one that put the plaintiff, Rodney Michael Cherry, behind bars.
Yeah.
Then we'll move through his sentence, the introduction of this particular law that blocked his path to parole, his audacious challenge directly in the High Court.
And the powerful, unanimous decision that came down from the justices. It's quite a story.
Our understanding, just so you know, is built directly from the legal documents, the ones filed in the High Court itself.
That's right. We've got the formal submissions from Mr. Cherry from the state of Queensland defending its law, and the detailed arguments put forward by several intervening attorneys general from other Australian states.
And we also have the official court orders, and crucially, the High Court's final binding judgment.
The final word.
So get ready. Our mission here is to guide you through the complexities of this legal showdown. We really want you to understand the key players involved, the procedural journey the case took, the high-level legal arguments debated before the nation's top judges.
And ultimately, why this ruling matters, why it's relevant to anyone interested in that intersection of justice, punishment, and, the foundational principles of Australian law.
It's a deep dive into true crime, but viewed through the lens of constitutional law.
Exactly. And to truly appreciate this legal drama, we really need to know who was standing in the ring, so to speak. Let's introduce the key figures.
Okay, at the center of it all is the plaintiff, the man who brought this challenge, Rodney Michael Cherry.
Mr. Cherry is the convicted killer in this case. According to the documents filed in court, he was found guilty of 2 counts of murdering his stepdaughter, Kira.
Right.
And the Supreme Court of Queensland sentenced him to life imprisonment. Now, that sentence included a mandatory minimum period in his case, 20 years that he absolutely had to serve before he could even be considered for parole.
So he served that 20-year minimum term. He did the time required by the judge. He became eligible for parole according to that judicial sentence.
He did.
But that's where the new law came into play, right?
Yeah.
That's the twist.
Precisely. He reached that eligibility date. But as the case documents and background materials make clear, a significant factor was his refusal to cooperate with authorities in locating Kira's body or her remains.
And that refusal.
That refusal, in the context of this relatively new no body, no parole law, became the direct trigger for the legal challenge we're talking about.
And his argument, his fundamental claim in challenging this law, what was he saying?
Mr. Cherry's legal team, and they were led in submissions and oral argument by A. Scott Casey and Ziggy Brereton. They argued that the Queensland law, specifically the part dealing with no cooperation declarations, that's Section 175L of the Corrective Services Act,
Right.
and related sections concerning restricted prisoners, Section 175E, they argued these were constitutionally invalid.
Invalid how?
Their core contention was that these laws allowed the executive branch of government, so the Parole Board, to essentially override or interfere with the punishment that the judicial branch, the Supreme Court, had imposed. They argued this went against a fundamental principle protecting the integrity of the courts.
Okay. Facing him in court, defending the state's law, was the state of Queensland.
The state of Queensland, yes, they were the defendant. Represented by the Solicitor General for Queensland, G.T. Del Villar Casey, leading their legal team, their mission was, the opposite. Convince the High Court that their law was perfectly valid under the Constitution.
And their argument?
Their central argument was the opposite of Mr. Cherry's. They maintain that the law didn't change or interfere with the Supreme Court's sentence at all. The sentence, they said, set the punishment and the minimum time.
Right.
The law, they argued, merely regulated the executive function of deciding whether to grant parole, which is a separate power, completely distinct from the court's role in sentencing.
Now, this is where it gets even more complex. It wasn't just Cherry versus Queensland. Several other states weighed in, didn't they? Backing Queensland?
They did.
Why did they get involved in the Queensland law? Seems a bit unusual.
Well, they intervened because cases like this, involving these big constitutional questions about state laws and the power of state courts, they have implications right across the country.
Oh, okay.
The Constitution sets up an integrated system of courts, you see. And a ruling on a principle affecting one state's Supreme Court can potentially impact all the others. So they joined under a section of the Judiciary Act that allows attorneys general to intervene when their state's interests might be affected by a constitutional question.
Makes sense. So who were these intervening states and what sort of angle did they bring to the table?
Okay, so the Attorney General for the Northern Territory was one, represented by their Solicitor General Nikolai Kristrup and Counsel Lachlan Spargo-Petey. They supported Queensland, and they added this interesting historical perspective to the debate.
Historical.
Yeah, they pointed to the historical existence of the executive's power, like the old prerogative of mercy granted by the Crown, which allowed prisoners to be released early.
Right, pardons and things.
Exactly. Their point was that these early release decisions have always been an executive function, separate from the judicial sentence, which suggests that judicial sentences weren't necessarily considered absolutely final in the way Mr. Cherry's team was arguing.
Interesting angle. And Victoria, what was their take?
The Attorney General for Victoria also intervened, represented by Solicitor General Alistair Pound SC and Fiona Batten. They strongly supported Queensland, too. They leaned heavily on past High Court decisions, cases like Crump, Knight, and Minogue.
Does sound important?
Very. These cases, Victoria argued, had already established that laws making it more difficult for prisoners to get parole do not amount to increasing the original sentence or interfering with judicial power. Restricting parole eligibility, they contended, doesn't make the sentence itself more punitive.
Okay. Western Australia also came on board.
Yes. The Attorney General for Western Australia, represented by Solicitor General C.S. Bider SC and Assistant State Counsel D. Van Nellestein, supported Queensland with a, well, pretty similar line of reasoning.
Consistent message, then.
Very. They argued that preventing a prisoner from even applying for parole wasn't fundamentally different, constitutionally speaking, from making it significantly harder to be granted parole, which the High Court had already said was okay. For them, the distinction Mr. Cherry's team was trying to draw was, in their words, a distinction without a difference, constitutionally.
And finally, South Australia joined the chorus too.
The Attorney General for South Australia also intervened, aligning with Queensland. Now, the specific names of their legal team weren't as prominent in the material we have, but their submissions offered a really structured counter-argument to Mr. Cherry's case.
What were their points?
They basically framed it in three parts. First, the Queensland laws didn't alter the punishment. Second, they didn't give judicial power to the executive. And third, they disputed Mr. Cherry's claim that this idea of the finality of punishment was an absolute defining characteristic of the Supreme Court's power in the specific way he needed it to be for his whole argument to work.
Wow. Quite a lineup of states supporting Queensland's position against, well, one man's challenge.
It shows the significance of the principle at stake.
And presiding over this complex legal showdown, interpreting the Constitution itself, the High Court of Australia.
The High Court, yes,
Yeah.
the final authority. The case was heard by a full bench of 7 justices. Chief Justice Giegler and Justices Gordon, Edelman, Stewart, Gleeson, Jagote, and Beach-Jones.
Full bench.
Yes. Their role was to determine if Queensland's state law was incompatible with the structure of the Australian Constitution, particularly how it defines and protects the power and integrity of the state Supreme Courts. Because, importantly, these state Supreme Courts can also exercise federal judicial power.
And this is where that Cabell principle comes in again, the one Cherry's case hinged on.
Exactly. It's all about ensuring state laws don't undermine the courts in a way that conflicts with their role in the national judicial system established by the Constitution.
All right, we know the players in the stage. Let's get into the nuts and bolts of the legal journey. How did this case actually unfold from the original crime right up to the High Court steps?
Okay, so it starts, of course, with the conviction and sentence. Rodney Michael Cherry was convicted of murdering his stepdaughter, Kira, by the Supreme Court of Queensland.
And he got that life sentence.
A life sentence, yes. A significant punishment. And critically, it included that mandatory minimum term of 20 years he had to serve before being eligible for consideration for parole.
And at the time of that sentencing, years ago, what did his life sentence actually mean in terms of potential release? What were the rules back then?
Well, back then, the parole system was governed by earlier legislation, the 2000 Act. It allowed for different avenues for release, including, importantly, consideration for standard parole once that minimum non-parole period had been served.
So the standard path.
The standard path, yeah. There was also a provision for exceptional circumstances parole, which could potentially be considered at any time, but standard parole was definitely tied to serving that minimum term set by the judge.
Okay. So fast forward 20 years. Cherry serves his minimum term. He becomes eligible, on paper at least, for that standard parole consideration. But the law had changed in the meantime.
Yes, this is the pivotal moment. While he was serving his sentence, the Queensland Parliament passed significant amendments in 2021 to the Corrective Services Act. And these amendments brought in the very laws he ended up challenging.
The no body, no parole law.
Exactly. The scheme for no cooperation declarations, which is the heart of the no body, no parole principle, and also the scheme for restricted prisoner declarations.
Let's zoom in on that no body, no parole part first, the no cooperation declaration.
Section 175L. How does that law work?
Okay, so Section 175L, it applies specifically to prisoners serving time for homicide offenses where the victim's body or remains haven't been found, or maybe part is missing due to the prisoner's actions or omissions. The law calls these people no body, no parole prisoners.
Right.
Now, the Parole Board is required to make a no cooperation declaration if they are not satisfied that the prisoner has given what the law calls satisfactory cooperation in helping to locate the victim's location.
Satisfactory cooperation sounds a bit subjective. Well, the law does set out factors. The board must consider things like police reports on the cooperation level, the prisoner's capacity to cooperate, even notes from the original sentencing judge about where the body might be.
And the effect of that declaration. What happens if the board makes one? Crucially.
This is the critical part, yes. If a no cooperation declaration is made under Section 175L, the prisoner is automatically barred from applying for standard parole, period.
Barred from even applying?
Correct. The only potential avenue left might be if they somehow become eligible later for exceptional circumstances parole, and that's also highly conditional. The declaration itself only lifts if they stop being a no body, no parole prisoner, which basically means if the body or remains are actually located.
Which explains Mr. Cherry's situation perfectly. Because Kira's body was not located, he was a no body, no parole prisoner.
Yep.
And because he refused to cooperate in locating her remains, the Parole Board made the declaration against him.
That's right.
And that act shut down his ability to apply for standard parole, despite having served his 20 years as required by the court.
Exactly. Now, there's also the other mechanism we mentioned, the restricted prisoner law, Section 175E. This is a slightly different beast, but it also restricts parole applications.
How does that one work? Who does it apply to?
So Section 175E applies to a category of restricted prisoners. And this category includes people serving life sentences for more than one murder conviction, which applied to Cherry.
Okay.
In this case, it's the president of the Parole Board, not the full board, who may make a restricted prisoner declaration about such a prisoner if they are satisfied it's in the public interest.
Public interest. What factors go into that?
Well, the law says they look at things like the extreme nature and seriousness of the offense, the risk the prisoner might pose to the public, and interestingly, potentially ignoring the effect of parole conditions that might manage that risk, and also the impact release would have on victims or their families.
And the effect of that declaration, if the president makes one?
If a restricted prisoner declaration is made under Section 175E, that prisoner is also barred from applying for standard parole. Again, the possibility of exceptional circumstances parole might theoretically remain.
And how long do these last?
These declarations can last for up to 10 years. And significantly, there's no limit on how many times they can be made. So you could potentially face rolling 10-year bans on applying for standard parole.
Wow, that's significant. What was Cherry's situation regarding this second law, 175E? Was a declaration made against him?
No, restricted prisoner declaration had not actually been made about Mr. Cherry under Section 175E. The High Court judgment specifically noted that one could potentially be made if his challenge to the No Body, No Parole law, Section 175L, succeeded, making 175L invalid.
A backup, perhaps?
Possibly. But because it hadn't actually happened yet and there was no guarantee it ever would, the court considered the question of Section 175E's validity to be hypothetical in his specific case.
So they didn't rule on it.
They declined to rule on it, which meant the main event in the High Court, the real legal fight, was squarely focused on Section 175L, the No Body, No Parole law.
Understood. Now let's look at the intentions behind these tough laws. What did the government actually say when they introduced them? Did they explain the purpose?
They did. The plaintiff's submissions, Mr. Cherry's submissions, highlighted statements made by the responsible minister when introducing the 2021 amendments in the Queensland Parliament.
What kind of things were said?
Well, the minister was quoted saying things like, "This bill introduces the strongest laws in the nation to keep the worst of the worst behind bars," and adding that prisoners could be banned from even applying for parole for a period of up to 10 years.
Right.
And explicitly stating the intent was, and this is a direct quote cited, to condemn the perpetrators of the worst crimes.
That language certainly sounds punitive, like it's adding extra punishment on top of the sentence.
That's exactly what Mr. Cherry's legal team argued. They seized on that language. They pointed to it as evidence that the purpose of the laws was punitive, to impose additional hardship or punishment beyond what the judge originally ordered, thereby interfering with the judicial role.
But Queensland and the other states didn't see it that way.
No, they pushed back strongly against that interpretation. They contended that denying parole isn't a punishment in the constitutional sense, because parole itself is seen as a grace or privilege granted by the executive, not some right that's part of the judicial sentence.
A mercy, not a right.
Essentially, yes. And interestingly, the Queensland Court of Appeal, in a separate case looking at the No Body, No Parole scheme, had actually viewed its primary purpose as encouraging cooperation to find remains for the sake of the victims' families, rather than being primarily punitive. So this differing view on the law's purpose was absolutely central to the debate.
So with his standard path to parole blocked by this new law, Section 175L, and armed with the argument that it was unconstitutional, Cherry initiated proceedings directly in the High Court.
He did.
Which, as you said, isn't the usual way cases get there. It really highlights the significance of the constitutional question involved.
It really does. He bypassed the lower state courts and went straight to the highest court in the land because his challenge was fundamental. He was claiming the state law was invalid because it encroached on the constitutional separation of powers. Specifically, he argued it interfered with the exclusive power of the judiciary to sentence criminals, and that this was contrary to the Cabal principle.
Okay, let's revisit the Cabal principle again, just to be clear. Remind us what that is and why it was the absolute bedrock of Cherry's argument.
Right, the Cabal principle. It's named after a high court case from back in the 90s, Cabal v. Director of Public Prosecutions, NSW. And it's absolutely essential to understanding this case.
Okay.
The Australian Constitution establishes a national integrated court system. State Supreme Courts aren't just state courts operating in isolation. They're part of this federal structure, and they can exercise federal judicial power.
Which is a big deal.
It is. And because of this role, the Cabal principle holds that state parliaments can't pass laws that give state courts functions or affect them in a way that is fundamentally incompatible with their institutional integrity as independent judicial bodies capable of exercising that federal power.
So you can't mess with the court's fundamental nature.
Essentially, yes. You can't make a state court do something or be something that undermines its core identity as a court as understood under Chapter 3 of the Constitution.
So Cherry's argument was that Queensland's laws, by having the Parole Board effectively interfere with what he saw as the finality of his sentence, were making the Supreme Court into something it constitutionally shouldn't be, undermining its integrity.
Yes, that was the essence of his argument. His legal team presented it as a kind of logical progression, a syllogism almost. They proposed a major premise. A core defining characteristic of a state Supreme Court's judicial power when sentencing is that the punishment it imposes is final and conclusive, unless, of course, it's changed on appeal by a higher court.
Okay, that's the major premise. Judicial punishment is final. And the minor premise?
The minor premise was that Sections 175L and 175E, by empowering the executive, the Parole Board, or its president to prevent him from applying for parole after his judicially determined eligibility date had arrived. Well, that they were effectively altering or increasing the punishment the Supreme Court had imposed.
So overriding that finality.
Exactly. They argued this executive power was overriding the finality of the judicial sentence, and therefore it was incompatible with the Supreme Court's institutional integrity under the Cabell principle.
Okay, makes sense as an argument. How did Queensland and the intervening states punch back against that? What was their counter?
Well, their counter-arguments were strong and multifaceted. They presented a very united front. Their primary response was simple. The laws just didn't alter the judicial sentence at all.
How so?
The sentence, they argued, is the head sentence life in this case, and the minimum non-parole period. The non-parole period set by the judge is just that a minimum time you must serve before you can even be considered for parole. It's not a guarantee of parole.
Not a promise of release.
Not at all. And it's not even a guarantee you'll be considered at that precise moment if other valid laws, like these parole laws, apply. They stressed repeatedly that the non-parole period gives the prisoner no more than a hope of potential early release. Just a hope.
So they drew a really clear line in the sand between the judge's job and the board's job.
Absolutely. They argued emphatically that the granting of parole is, and always has been constitutionally, an executive function, completely separate from the judicial function of sentencing.
Once the judge bangs the gavel.
Pretty much. Once the judge has passed sentence, the judicial power in that respect is spent, as they put it. The responsibility for managing the prisoner and deciding on conditional release passes squarely to the executive branch.
And they brought in that historical point again here, about the prerogative of mercy.
Yes, particularly the Northern Territories submissions highlighted this. They argued that the historical existence of powers like the prerogative of mercy, where the king or queen, the executive, could release prisoners early, even against the term set by the judge, demonstrated that this idea of a judicial sentence being absolutely, finally, and conclusively final in the way the plaintiff argued wasn't historically accurate or constitutionally mandated in that strict sense.
So the executive always had a role in release.
That was their point. Now, Mr. Cherry's legal team, in their reply submissions, tried to distinguish this. They argued the prerogative was an existing executive power inherent in the Crown, not a legislative power passed by Parliament specifically to interfere with a judicial sentence after the fact. A subtle but important distinction in their view.
And those previous high court cases, Crump, Knight, Minogue, they leaned on those heavily.
Definitely. Queensland and the interveners saw Crump, Knight, and Minogue as crucial precedents. They argued these cases had already laid down the principle. Laws making parole harder to get didn't unconstitutionally interfere with the judicial sentence.
What had the court said in those cases?
The High Court in those cases had essentially said that simply making it more difficult to obtain parole or adding new conditions didn't amount to increasing the punishment set by the court. It didn't change the sentence itself.
But Cherry's team said their case was different, didn't they? Because this law didn't just make parole harder to get, it stopped him from even applying. That seems different.
Yes, they tried hard to draw that distinction. It was a key part of their argument. But the state side argued this was, well, splitting hairs constitutionally. They contended that the legal effect was ultimately the same, preventing the executive from granting parole under certain conditions.
Not a real difference in effect.
That was their argument. They also pointed out that Mr. Cherry still had potential avenues available to him. He could, theoretically, regain eligibility under the no body, no parole law by cooperating. Or he could potentially apply for exceptional circumstances parole down the track. So the law didn't completely extinguish all possibility of executive release, it just conditioned it very heavily.
And what about the punitive purpose argument? Citing the minister's words about condemning criminals and keeping them behind bars, did that hold any water with the states?
Queensland and the interveners pushed back hard on that too. They argued that regardless of what the minister might have said in Parliament political speech, essentially the legal effect of the law wasn't to add punishment to the sentence itself.
How did they square that circle?
They argued that denying parole, which they consistently characterize as withholding a mercy or privilege, is fundamentally different from imposing a punishment in the legal sense. They also pointed out, as you heard in the oral arguments from Mr. Del Villar for Queensland and Mr. Pound for Victoria, that the purposes actually stated in the law itself related to encouraging cooperation to find remains or assessing public interest and risk, which, they argued, are legitimate executive considerations for parole decisions, not judicial ones for sentencing.
And that reference to the Minogue case.
Right. They also noted, as the High Court later did in its judgment, that Justice Edelman's observation in the Minogue case about a law potentially having a punitive purpose needed to be read carefully in the context of that specific case. In Minogue, the law being considered didn't actually change the fundamental legal operation of the sentence or parole eligibility in the way Cherry argued this law did.
So the battle lines were clearly drawn. Finality of judicial sentences versus the scope of executive power over parole. How did the case actually move through the formal steps in the High Court? What was the process?
Okay, so the case began with Mr. Cherry filing his application directly in the High Court's original jurisdiction. Given the constitutional nature of the challenge, the Chief Justice, Justice Gagler, made an order allowing the parties to agree on what's called a special case.
A special case, what's that?
It's basically a way for the parties to streamline the process when the facts aren't really in dispute, but the legal question is. They agree on a set of facts and then formulate the specific constitutional questions they want the High Court to answer. It avoids the need for a full trial on the facts and lets the court focus purely on the legal arguments.
Makes sense. So they agreed the facts, set the questions, then came the detailed legal arguments on paper.
Exactly. The Chief Justice's order set out a strict timetable for the exchange of written submissions. Mr. Cherry's legal team, led by Mr. Scott Casey, filed their extensive argument first, laying out his case based on the cable principle.
Then Queensland responded.
Yes, the state of Queensland, led by Mr. Delviller Casey, filed their detailed response, defending the validity of the law, arguing it was purely about executive power. Following that, the attorneys general from the Northern Territory, Victoria, Western Australia, and South Australia all filed their own submissions, weighing in to support Queensland and adding their specific points drawing on history, precedent, and constitutional structure.
So everyone got their say on paper.
Everyone did. And finally, Mr. Cherry's team filed reply submissions, responding directly to the arguments raised by Queensland and all the intervening states. This massive exchange of written arguments provides the court with the full breadth and depth of each side's position before they even step into the courtroom for the hearing.
After all the paper was filed, thousands of pages presumably, it went to oral argument before the judges.
Yes, the final stage before judgment was the hearing before the full bench of the 7 High Court justices. This case was set down for just a single day of oral argument, which tells you how focused the questions were.
One day for all that.
One intense day. Barristers for each party, Mr. Scott Casey for Mr. Cherry, Mr. Delviller Casey for Queensland, and counsel for each of the intervening states, Mr. Kristrup for the NT, Mr. Pound SC for Victoria, Mr. Beater SC for WA, and counsel for SA, stood up and presented their cases directly to the justices.
And the justices grilled them.
Oh, yes. They answered pointed questions from the bench, defending their positions, clarifying nuances, trying to persuade the court of the strength of their arguments. These oral arguments are absolutely crucial for the court to probe the issues, test the limits of each side's position, and clarify anything unclear from the written material.
So the arguments were heard on that one day, 4th February 2025.
Mm-hmm.
And then the justices went away to consider everything. That must have been a tense wait. When did they deliver their verdict?
The High Court delivered its unanimous judgment a couple of months later on 9 April 2025. And importantly, all 7 justices who heard the case agreed on the key outcome regarding the no body, no parole law, Section 175L.
Unanimous. That's significant. Let's get straight to that key question then. Question A. Was the no body, no parole law, Section 175L, invalid because it allowed the executive to impermissibly interfere with the judicial power of the Supreme Court, contrary to the Cabell principle? What did they say?
The High Court's unanimous answer to that crucial question was a clear and resounding no.
Wow. Straightforward no. So they upheld the law. What was the core of their reasoning? How do they explain that the law didn't actually interfere with the judicial sentence, despite its effects?
Well, the court's reasoning really came back to those foundational principles that were debated so heavily by the parties. They strongly reaffirmed the fundamental distinction between the judicial function of sentencing and the separate executive function of administering that sentence and deciding on parole.
That dividing line again.
Exactly. They emphasized that once the Supreme Court imposes a sentence, including fixing a non-parole period, the judicial power in relation to the severity or duration of the punishment imposed by the court is effectively spent. It's done its job. Responsibility for the prisoner's management and potential early release then squarely falls to the executive branch, primarily the Parole Board operating under laws made by Parliament.
So that minimum non-parole period, the 20 years Cherry served, doesn't give you a right to be released or even considered.
Absolutely not. The High Court was crystal clear on this point. They stated very plainly that the non-parole period simply sets the earliest date a prisoner may be considered eligible for parole by the executive. It does not create any right or entitlement to be granted parole, or even a right to be considered for it at that precise moment if other valid laws prevent it.
Just the hope.
All it gives the prisoner, the court explicitly said, echoing the state's argument, is a hope that the executive might choose to grant parole at or after that eligibility date. Nothing more legally binding than that from the sentence itself.
And the fact that the parole laws changed after Cherry was sentenced, did that matter?
The court confirmed that the legal framework governing parole is statutory, meaning it's created by Parliament, and Parliament can amend it over time. Changes to these laws, even if they make obtaining parole significantly more difficult than it was when the sentence was originally imposed, do not by themselves mean that the original judicial sentence is being altered or made more burdensome in a constitutionally problematic way.
Yeah. They also addressed the comparison to the previous cases, Crump, Knight, Minogue.
Yeah.
Did they agree with the states on that?
Yes, very much so. They found that Section 175L was not materially different in its constitutional implications from the kinds of laws they had already considered and upheld in those earlier decisions.
Even the fact it stopped him applying, rather than just making it harder to be granted parole.
They directly tackled that specific argument, the distinction Cherry's team tried to draw. The court concluded this was not a constitutional significant distinction.
Why not?
They reasoned that the ultimate legal effect was similar. It restricted the executive's power to grant parole based on criteria set by Parliament. And importantly, they noted Mr. Cherry still had theoretical pathways to potentially gain consideration. He could end the no cooperation declaration by cooperating, or he might in future be eligible to apply for exceptional circumstances parole. So the law didn't completely extinguish the executive's power to release him early. It conditioned it, albeit very strictly.
What about the plaintiff's argument that the law's punitive purpose, as suggested by the minister's quote about condemnation, made it unconstitutional? How did the court handle that?
The court didn't accept that argument as sufficient to invalidate the law in these circumstances. While they acknowledged the debate around the law's purpose, they ultimately came back to its legal effect on the sentence.
Effect over purpose.
In this context, yes. They reasoned that denying parole, which they consistently characterized as the executive withholding a mercy or privilege, doesn't convert the original judicial sentence into something more punitive, even if some might see the law's motivation as punitive. They also clarified that Justice Edelman's comment in the Minogue case about a potentially punitive purpose needed to be understood in the context of that earlier case, where the law in question didn't actually change the fundamental legal operation of the sentence or parole eligibility in the same way. So in the end, the High Court's unanimous conclusion on Question A was crystal clear, and I'll quote the summary. Section 175L did not in any way operate to alter or increase the plaintiff's sentence, nor impose upon him additional punishment. Therefore, it did not violate the Cabell principle by interfering with the judicial power of the Supreme Court.
So, the no body, no parole law in Queensland was held to be constitutionally valid. End of story for that part. What about the second question, question B, concerning the restricted prisoner law, section 175E? What did they say about that one?
For question B, the court simply stated, no answer is required.
No answer required. Why not?
As we discussed earlier, they declined to rule on the validity of Section 175E because a restricted prisoner declaration had not actually been made about Mr. Cherry under that section. Since it hadn't happened and might never happen, the question of its validity in his specific circumstances was hypothetical. And the High Court generally avoids ruling on hypothetical scenarios like that.
Right, they stick to the actual facts before them. And question C, which was about an older version of the law, what happened there?
Question C was a fallback question. It only arose if Section 175L had been found invalid. It asked if a former version of the no body, no parole law, an older Section 193A, which the 2021 law replaced, would then apply to Mr. Cherry.
But since 175L was upheld.
Exactly. Since the court upheld Section 175L as valid, this contingent question simply did not need to be answered. It became irrelevant.
Finally, what about costs? Legal battles in the High Court must be incredibly expensive. Who pays?
That's always a big question. The initial order from the Chief Justice setting up the special case had noted that costs were reserved. The final judgment itself doesn't explicitly state the final costs order.
So we don't know for sure.
Not from the main judgment text provided. It likely means the court made a separate order regarding costs after the judgment was handed down, or perhaps they were subject to further negotiation between the parties based on the outcome. But typically, in constitutional cases like this, especially involving the state defending its legislation and multiple interveners, costs can be a very significant factor, often following the event, meaning the losing party might be ordered to pay the winning party's costs.
Right. This has been a fascinating deep dive into a truly significant legal case. We've seen the journey from, well, a horrific crime to a major constitutional showdown in the High Court. So, bringing it back to our listener, what does the outcome of Cherry v. Queensland mean for you? Why should people care?
Well, if you're someone interested in true crime, this case vividly illustrates how the legal system responds, sometimes quite directly, to public concern and evolves over time. These no body, no parole laws were undoubtedly a response to the anguish of victims' families unable to locate their loved ones' remains.
A very understandable anguish.
Absolutely. And the case shows this deep tension between the fixed punishment handed down by a judge years ago and the dynamic possibilities or lack thereof for release decades later, heavily influenced by a prisoner's subsequent actions and, crucially, by legislative changes made long after the original sentence. Mr. Cherry's case put that tension to the ultimate legal test.
And if you're fascinated by the machinery of the legal system itself, how things work,
Then this case is really a masterclass in Australia's separation of powers doctrine. It clarifies those boundaries. The judiciary determines guilt and imposes the sentence, which includes setting that minimum non-parole period. But then the executive manages the prisoner population and decides whether to grant the privilege of early release through parole.
and the High Court reinforced that line.
Very strongly. The judgment is a powerful statement reinforcing that line, making it clear that while Parliament can regulate the executive function of parole quite severely, it cannot do so in a way that is deemed to impermissibly interfere with the judicial power of sentencing itself. This application of the Cabal principle is fundamental to maintaining the institutional integrity of our courts.
The ruling seems to strongly validate the executive's power over parole, maybe more than some people realized.
I think that's fair to say. The decision in Cherry v. Queensland reinforces the principle that in Australia, parole is viewed constitutionally not as an automatic right earned simply by serving a minimum term, but as a privilege, or, as the court sometimes termed it, a mercy, that the executive government has the power to grant or withhold.
And Parliament sets the rules for that mercy.
Exactly. And crucially, Parliament has significant power to set the rules and conditions for obtaining that privilege, even if those rules change substantially after a sentence is handed down. The High Court has now confirmed that even preventing a prisoner from applying for parole under certain conditions, like non-cooperation, does not necessarily cross that constitutional line into interfering with the original judicial sentence.
And given that several states intervened, supporting Queensland, this decision has implications beyond just Queensland, doesn't it?
Oh, absolutely. By upholding Queensland's no body, no parole law under Section 175L, the High Court has provided very strong authority for the constitutional validity of similar schemes in other states or territories or any future ones. It sends a clear signal that laws conditioning parole eligibility on cooperation in locating remains or other laws placing significant restrictions on parole applications based on executive assessments are likely to be considered valid under the Cabal principle, provided they don't fundamentally alter the legal effect of the judicial sentence itself. It's a very significant precedent for parole laws right across Australia.
So our deep dive into Cherry v. Queensland has taken us through the stages of a really compelling legal battle, sparked by a tragic crime and brought all the way to the highest court in the land. We've seen the core arguments challenging the no body, no parole law on fundamental constitutional grounds.
And the High Court's decisive, unanimous answer to that challenge.
It's a ruling that firmly distinguishes between the court's role in sentencing and the executive's separate role in managing parole. It reinforces that long-standing principle that parole is a discretionary executive function, not some automatic entitlement flowing from the judicial sentence.
That's the key takeaway.
The High Court upheld Queensland's no body, no parole law. They found it did not unconstitutionally interfere with the Supreme Court's power to sentence. Rodney Michael Cherry's challenge, at least on the primary point regarding the validity of Section 175L, was ultimately unsuccessful.
The High Court maintained that crucial boundary between the power wielded by the judiciary when imposing punishment and the power exercised by the executive when considering early release, a clear line.
Now, the no body, no parole law requires satisfactory cooperation from a prisoner to find remains before they can even apply for parole. But even after the High Court has settled the principle in this case, it leaves you, the listener, with some profound questions to maybe consider. The law sets a standard for cooperation, but what exactly defines satisfactory cooperation to a parole board, potentially decades after a crime? How do they judge that? And what happens in those incredibly difficult, truly heart-wrenching situations where, after so much time has passed, a prisoner might genuinely no longer recall crucial details? Or perhaps they continue to steadfastly maintain their innocence, which would inherently seem to preclude cooperation as the law intends it.
Difficult questions indeed.
The legal question of the law's validity, whether Parliament can make such a law, that's now settled by the High Court in this case. But the complex human questions behind these laws, the practical application, and of course the ongoing anguish for the families who still desperately seek closure on the remains of their loved ones, those remain.